Hello, everyone, and welcome to the live stream. It's Monday, the 16th of December 2024, and unfortunately, Shannon can't be with us today, but we've got, I'm lucky to have Mike and Karis here, and we haven't got a huge load of stuff to talk about, so comments much appreciated if people have them, and what we thought we'd talk about to start with tonight, though, is my favourite subject, Section 189A of the Housing Act 1996, and personal assessments and personal housing plans. But before we dive into that, is there anything you guys would like to talk about or say?
No, not specifically.
Okay. Right. So what I'll do is I'll just line up the comments thing so that we can, if we get any comments, we can put them in there. Right. So I'll take that off. So what I wanted to do today is have a chat about Section 189A, and I've got a screen there I can share. Which will hopefully set out some material. If you want to see this, it is actually from my blog. I don't know, it's quite a long time ago that I posted this, but I was trying to get my head around what Section 189A meant, and so I wrote out these notes, and I'd forgotten about it, but it's quite useful to find it again. Now, the starting point here is that if you go to see a housing advisor or a housing lawyer, what you should get is somebody who's sympathetic and is looking into solving the problem that you've come about, and that's the sort of understanding you go on. And I think it's the same if you go to an advice agency or a support group. You know, it's not a sort of attitude of, oh, what are you doing here, and I'm not sure if we can help you, and But when people go to local authorities, there's a sort of assumption that you're going to be. I apologise to people from local authorities who think I'm being unkind, but the general perception is that you're dealing with people who are at the best sort of begrudgingly helping rather than sort of anxiously or concerned about your well-being. Would you agree with that, guys? So
Yeah, I think I was just going to say, I guess because we tend to see things when they've gone wrong,
yeah,
possible that we've got some sort of inbuilt bias into that. However,
definitely.
when I worked at Bedford Borough Council, which is pretty typical, I think, I think most housing officers, but your kind of approach was, okay, how do we not house this person? How do we get out of it? What's the kind of argument we can use to get rid of them, rather than as you say, actually being there to help someone out. So I don't know, it'd be interesting to kind of how you could actually gather that kind of intel without doing secret shopper type reports.
Yeah, well, assuming that it isn't totally me being biased, I'll proceed on the basis that housing staff, for whatever reason, are seen as less friendly and less engaging, and less looking to help people out, rather than just sort of providing a statutory service. And I think that ties in with a lot of people saying to me, why are they being so horrible to me? What did I do to them to make them like that? So the reason I'm going back to Section 189A is that the Homelessness Prevention Act, although it came at a strange time, because it's the end of it's a Conservative government at the end of quite a long strain of sort of austerity and not overwhelming friendliness towards poor people, although they did have the sort of go through the motions of having levelling up a couple of years later, which I always thought was a bit of a gimmick. But nevertheless, what they came up with was, I think, a very far-seeing and potentially, I don't want to use the word revolutionary, but really something that would make a big change to the way that homelessness services operate, which I don't think has been appreciated, and I don't think by anybody on either side of the sort of barricades, as it were. And I'll just explain what I mean, because when I sort of said the bit about the the approach should be towards problem solving and actually seeing the homeless applicant as somebody that needs help rather than looking for an excuse not to help them, which is what it used to be with. You'd make inquiries and think, well, how can we? I mean, I think you used the expression, Mike, wasn't it? We'll find the easiest way to get rid of them first and use that. So what used to happen is that the local authority would just have to make inquiries as to whether they accepted a duty, and that, as I say, often meant making inquiries to see if they could find a reason for not accepting a duty. And then when they found a duty, when they accepted a duty, it was very much a case of, well, consider yourself lucky, we're going to offer you something now, and that's your lot. If you raise issues of suitability, then you're seen as sort of being difficult. Or put another way, the local authority wasn't really in a very good position to decide whether it was genuinely unsuitable accommodation they were offering you, because they'd only been looking at whether you were entitled to be housed, not what kind of housing you needed. So I think the government recognised this, and that's why they said that in addition to deciding whether to accept a statutory duty, local authorities had to carry out an assessment of a person's housing needs and then draw up a plan together with them for how to meet those needs. And the assessment needs to cover how they became homeless, and then moving on from the usual approach, then considering what is suitable accommodation for them and what support they need. So really, if you think about it, they're doing very much the same job as we are, but strangely, it hasn't really materialised yet. There's still this sense that we're the ones who sort of help people to overcome problems, whereas the council are sort of struggling with the limited resources and what have you. So just to move on a bit, the actual wording of the statute, I'll just come back to it here, says that where somebody is, where the local authority is satisfied that somebody's homeless and eligible, then they must make an assessment of their case, and that includes those things. So it's really anybody that's homeless, and this is important because it's not just people who are in priority need. And there is generally a feeling that people who aren't in priority need aren't going to get anything, even though the relief duty suggests that they should be getting help in finding somewhere. But traditionally, that duty's been discharged by sort of giving someone a leaflet and sending them on their way. But here it's a more serious duty to assess their needs as well and provide them with assistance. And of course, that covers everybody who's got to the homeless stage. Arguably, I suppose it doesn't. Well, I suppose threatened with homelessness would cover people who are owed a prevention duty. Would you guys agree with that?
Sorry, Will, I was just replying to Cheeseface in the chat. Say the question again.
I think that actually, I was about to say it doesn't cover the prevention duty, but I think threatened with homelessness means that it does cover the prevention duty, which is important because it means you've got to look into the thing seriously. It's not just a question of saying, as a lot of personal housing plans are limited to saying you need accommodation, and the plan is we'll help you find it, full stop, and that's it. It doesn't go into very much detail. And if you look at the Code of Guidance, I'm not going to go into that in huge detail, but it's here. The wording that you get here is very much the idea that a local authority should be working collaboratively. Oh, sorry, I didn't bring up the Code of Guidance. Where did it go? Sorry. Code of Guidance, Chapter 11. Yes, sorry, there it is. So if you read through Chapter 11, the wording you get and the spirit which the council, I think, are encouraged to adopt is very much the same as us. It's working collaboratively with people and carrying out a proper assessment and following at least one interview. And it should also mean that they should be aware of their other statutory duties, such as social services duties under the Care Act. Now, if I give you an example of how powerful these new obligations are, if we go into I'm not sure if these cases will come up properly when I indicate them, but I think if I think I've gone to the tab here for the Nearly Legal blog. I've got a report on a case called Myro Marek versus Westminster. What's really interesting about this, as with the other case I'll mention, is that Mr. Marek is somebody who, on the face of it, doesn't appear to be in priority need. Or he may have been, but the key thing here was that they didn't find anything for him, but he challenged the decision, and one of the things they said was that the council, I think it was this one, ground one, was that they'd failed to consider whether the council's assessment and personal housing plan met the statutory requirements. And this was premised on the submission that a local authority's proper assessment of an applicant's care case and agreement of a PHP are conditions precedent for the steps they are to take under section 19B. And then simply put, which is well, because I think I garbled that a bit, unless the council understands the applicant's case, it can't know what's suitable. So if they offer somebody something unsuitable, you've almost got a challenge. Regardless of whether or not it was a good place or not, you can say, well, they didn't know what was suitable for this person because they didn't carry out a proper assessment. So if you can get the assessment report, as happened in this case, and find that there hasn't been a proper assessment, then the council simply can't say what's suitable. Often what happens is they offer something suitable, you then express your objections to it, and then they say, oh, we've thought about this, and no, we don't agree with that, we don't, and then they basically knock down your arguments. But here, you'd have to say, well, they never actually carried out a proper assessment, so the onus is on them. And then the second challenge, now this is really interesting. It's because they didn't. I think the argument here was they were saying, well, sorry, we can't find you anything. And I think it was a sort of relief duty case, because otherwise they would have been under a duty. But here, they were found to be at fault because they hadn't assisted him in making an application under Part 6. Now, I think that's really relevant to the sorts of questions we get on the two live streams, because without wishing to be disrespectful to the people that ask the questions, there's a widespread misunderstanding about the relationship between Part 7 and Part 6, and priority need and priority lists, and even whether you are entitled to automatically be put on the housing register when you apply as homeless, and where you would go on the housing register. And there's a general feeling in the profession, and that spreads to the legal profession as well, that they're totally separate. And I'm guilty of this, because I'm always saying, well, you're unlikely to get a council place by applying as homeless, and you have to resign yourself to private sector. But here they're saying, what basically happened was they were saying, sorry, we can't find anything for you. And he challenged it by saying, well, you haven't helped me make a Part 6 application. And understandably, they came back to the response to that was, well, it wouldn't have made any difference because he's a single man. He's unlikely to get a council place. But they looked in detail at the policy that the council had, and it meant there were grounds on which he could have been offered a council place, but they just simply hadn't looked at it. So that was a challenge. Basically, the judge didn't say you've got to house him, but he said, go back and make another decision, because at the moment, A, you don't know what his housing needs are, and B, you haven't helped him make a Part 6 application. So I think the takeaway points from that case are that really local authorities should be pressed to say what they've done about helping somebody make a Part 6 application. And if they haven't done it, then it may be a ground to challenge the suitability of what they have offered, especially if they also haven't done a proper assessment. And then there's one other case I'm going to mention, and I'll stop talking in a sec. If I go back to, I think it's if I go in my browser, it may take me there. Yes, can you see that? I think this case is what. No, I'm sorry, I haven't gone into it in enough detail. I think it's this case. Sorry, this is an article by Connor Johnson from Garden Court on a case from 2016. So you may think, well, how did that get decided? Because that's before the Act came into effect. But I'm not quite sure how that happened. I think it was to do with the duties to assess that arose under the previous law. But note that this was the case where they used the term nuts and bolts, I think. Yeah. And it was this. And it goes back to the detail that you need to go into when doing the assessment. You can't just say you're homeless and you need accommodation. You've actually got to look into what the particular needs are. And that hadn't happened. And again, this related to section 190, which is the one where you're intentionally homeless but you're in priority need. And they said that they hadn't carried out a proper assessment. They hadn't looked into the actual detail. And so you can, if you combine that with the other case where they said they weren't in a position to decide what was suitable or whether they'd done all they could do because they hadn't assessed him. You take it a stage further here, they can say, oh, well, we did an assessment, but you can say, well, you haven't actually identified the nuts and bolts of this person's needs, so you haven't done an assessment, and therefore you can't say you couldn't have done more. And that's going to affect everybody, but it affects people who are intentionally homeless as well. So that's the end of my talk on that section on the section 189A and so forth. I hope that's helpful. I'm just trying to get back to where I started, but I won't. But I think we should keep talking about this because it's going to come up time and again. And I think if we can just encourage a sort of sea change in the way people think about section 189A, or just think about the homeless process. It should be a process of helping people, and in order to help them, you need to assess what help they need and then look into taking detailed steps to providing it. And so that's it. I'll just put... Does either of you want to come back on any of that?
I suppose we've got a question. So what happens with when they haven't done a harmful assessment? That's where we come in and try and enforce it. But if someone doesn't have access to a solicitor, it would just be through making complaint about the housing officer. Or if they've got to wait a long time for the assessment to take place in the first place.
Yeah, I mean, I think if somebody, I mean, it's always going to be a problem if you haven't got legal representation or you haven't got help from somebody who knows their way around the Housing Act, because they obviously can't spot the errors that have been made and don't know what to do when they do, if they did spot them, which is, I mean, whether you go for a judicial review or a complaint or an internal review. But I guess the thing to do, if I could encourage people who aren't specialists to be asking for, is ask for a copy of your assessment report and the personal housing plan. Now, you will very often get an answer, because my experience is that local authorities are still almost 90% are not drawing up coherent assessment reports. And their argument, and this goes back to the problem that we come into this with, they'll say that we did an assessment and it led to a section 184 notice, so why do we need to do another one? And you hear that a lot. We've assessed everything and it's all set out in the section 184 notice. Well, of course it isn't, and they haven't assessed, because in the 184 they're just asking those 5 questions. Are you eligible? Are you homeless? Are you intentionally homeless? Are you in priority need? And do you have a local connection? And really all you're trying to do is say yes to those. You're not actually saying what the person, how they became homeless. If they didn't become intentionally homeless, then they're not particularly interested. And it may be relevant because you may have lost... I had a case the other day of somebody who's... I've got it, it's still going on actually. Somebody who's challenging vulnerability, and one of the reasons he became homeless, well, the reason he became homeless was because his landlord had said, I'm sorry, but you fell asleep in the kitchen with the oven on and you put the house in danger of burning down, so you've got to go. Now that's really relevant, because if they try to say, well, you're not in priority need, You might have, you've got an extra argument. Say, well, he's got a serious medical condition which actually led to him losing his home. I think you've got to ask for that assessment report, and if they haven't got it, then make a complaint about not having a report, and then complain about not having it considered if you're offered something. But again, I mean, it's difficult to actually get teeth with these things if you haven't got legal representation. I'll just put a couple of these comments up. We've got Cheeseface. Oh, thank you very much. I like it when people say 100% correct, Will. I was watching one of Mike's older vids 4 years with ×3 judges, and one of the judges said they should work back to front because of the housing shortages. Sorry, I've got a thing in the way. Shocked to find out that walking into an office and saying "give me a housemate" is not enough to trigger an application, if I understood it correctly.
You've misread that. Well, it says walking into an office and saying "give me a housemate" is enough to trigger an application.
So is enough. I beg your pardon. Is enough.
Is in the context of a homeless person's unit. So I think that's probably where you kind of get the reason to believe that they're homeless. But yeah, it had Jan Lube was kind of talking quite a lot on that one about just that initial Section 184 threshold. And interestingly, I noticed that he seems to be at odds with other judges on whether a duty to refer would constitute an application, because he was basically saying, like, if you've given your consent for that form to be sent off, then that's you indicating that you want the council to help you out with housing. But then that's kind of a tangent, I guess. But it's interesting. Even in his textbook, he kind of says, this author's opinion that the way the law's been interpreted is wrong on the duty to refer issue.
Yeah, it's so thank you for your comments there, Cheeseface, and that's what I wanted to say about that. Mike, you were mentioning about, it sort of overlaps with what I was saying, which was the about how much we expect housing staff to know the law.
Yeah, I mean, going back a step, I'd respectfully disagree with your perspective on the Homelessness Reduction Act, because whilst I guess as you've just laid out, there is, it's what it's trying to do is trying to legislate for housing officers being helpful, and it's trying to make it so that housing officers will be more helpful. But what it's actually done is just make it very, very obscure and kind of opaque. And there's I can't remember if I talked about it before. There's a really important book called Street Level Bureaucrats. I think Street Level Bureaucracy by Michael Lipsky, and it was debated in the House of Lords or House of Commons or whatever when they brought the Care Act in. And his whole thing is it doesn't matter what the top bods say about kind of practices and kind of culture and stuff. It's what happens in the front line. It's the frontline workers that have actually all the power when it comes to how they approach these kind of it's exactly like what we're talking here, a bureaucratic process. And actually, the fact that the HRA is trying to get housing officers to be more helpful, they just ignore it. And actually, because it is so ridiculously complicated. If you ever read sort of chapters 11 to 16 of the Code of Guidance, it's just this is insane. There's points where it doesn't even make sense. As in there's bits where I don't think even the people writing it thought it through. So I think whilst if you're a solicitor, you can kind of you can see if the nuts and bolts were kind of looked into and you can challenge it. I'm not quite sure. It's just very difficult to do that, and you've now got a sector which is less resourced as ever, than ever. Legal aid's presumably sparse than ever to actually support people to do it. So, what the HRA has actually done, whilst it might have had good intentions, is it's just basically assumed that they could change the culture of housing officers with legislation, when actually the problem was the existing law wasn't being followed. That's why it was bad. That's why it was going wrong, and what they did, rather than kind of fix the issue, which was lack of resources, they put in this even more onerous bit of legislation in place, which just basically amplifies the injustice. There's very little in it. I just think, this is better than it used to be, because as I say, to get the council to properly assess someone, you've got to fight for just that assessment for them to do it properly and not use a template. And so it's just, housing officers now kind of, are just tied up with all these different letters they've got to send out, so they're even less likely to respond to people who've got questions. So I think it's a classic example of not necessarily just Tory government, but just any government thinking that they can do this stuff without listening to people who were on the front line, because there's no way they did. There's no way that they went in and kind of spent time at length with frontline workers and homeless people saying, this is what we think would improve it. What do you think? Because no housing officer would say, yeah, this sounds like a good idea, because just how ridiculously convoluted and onerous it is. So, yeah, I think it was a mistake, and I think things would be better if it went back to the old kind of 5-part test stuff, and just work on fixing the housing crisis, I guess. But yeah, I think that kind of question of, I think you raised it in the last live stream. You say, well, to what extent can we expect housing officers to know the law? And I'd say, even before the HRA came in, it was complicated. Things like the definition of priority need has always been quite complicated, as is suitability. But now you're expecting housing officers to have a working understanding of those really kind of convoluted chapters about the prevention relief. The bit I'm thinking in particular, that doesn't make any sense, and I think it's chapter 16 maybe, effectively says you can make a final accommodation offer in the relief period, but if they're in priority need, then it has to be of a better standard, as in if they're vulnerable. But then at this stage, you don't know that they're in priority need yet, so it doesn't make sense. There's no way to challenge that. There's no possible way to challenge it, because someone who is in priority need through medical issues and so on, they can't prove that they're in priority need. And so if they were to challenge the quality of the accommodation they were given, the council would just say, well, you're not in priority need, what you're talking about. And there'd be actually no coherent way to challenge that offer. So that's just, I think that's the one example which makes no sense at all. But then there's other bits which kind of reference the wrong bit, and it was just a mess. So I don't think, given that, housing officers tend to be, I don't know, then, they certainly don't have legal qualifications most of the time, to expect them to get a handle on it and to apply it properly when their boss is telling them to break the law is just I don't know, it just seems to be a non-starter, really. So I don't know. I don't know what you guys think about that, but that's I think that's my position on it. I just think, the HRA was trying to fix a problem completely the wrong way, and it was foreseeably the wrong way as well. It's just, as I say, it's just kind of, I don't know, civil servants and politicians just being incompetent. Maybe with maybe they're good intentions, but that's just, there's no way that was going to work.
I do sort of agree with you.
Also,
Oh, sorry, Caris. You please speak. I shouldn't hog it.
the housing officers have no accountability, so there's no, if they get complained about, they swap person. If there's a complaint, is there a record of that officer having the complaints and what they've been complained about, so they don't do it again? Training in that way, so they brought in a whole other legislation to fill the gap when the people enforcing that legislation, don't understand it, don't want to understand it, and aren't accountable for their actions. So if you're not having that very basic structure of these people that introduce this law need to have accountability for what they're doing and the things they're implementing and the things that they're doing unsupervised and on their own fruition. So you're having law that there's a big gap in what people can actually access. The whole thing is quite inaccessible anyway, because there's not enough legal aid solicitors in housing now across the country, and there's no accountability for the officers. Do they get fined that when they do an assessment and it's wrong, or they just do a negative decision because they can? They should be fined, they should be accountable, it should be held on record what they've done. If they've been discriminating someone against their disability, race, it should be a record of their complaints, what they've done, and things like that. That would address practical issues rather than putting another legislation in place that people can't access. Sorry, that was very long-winded.
No, it's a good point.
I was going to take it one more level of cynicism, Caris, to basically say that managers specifically like having people on their team who are gatekeepers, and they know it. And so temporary housing officers now, I have actually met a couple of decent temporary housing officers, so it's not that they're all terrible, but most of them, in my experience, absolutely are. And when councils use temporary housing officers, I would say that they implicitly know what they're getting. They know they're going to get a housing officer that just basically in terms of the overall kind of case. But there was a couple of temporary housing officers came, and one was team leader, made an outrageous decision about someone leaving psychiatric unit. And I complained about it. And by that point, I thought that the chief officer of the housing department kind of took us seriously. And before we knew it, he'd been promoted. And then there was this 4-month period where just carnage, and they regretted it ultimately because they got ridiculous kind of complaints against them at the end of it. But again, they were kind of, there was no way that person should ever have been promoted. They were willfully just ignoring someone's very serious medical issues, and yet they, as I say, they were rewarded for it. And so I think I think housing managers, in the interview process, I'm sure that they're asking questions that are essentially going, working out, okay, does this applicant know the game? Do they know how to kind of get rid of people? Do they know how to use use this cloaked language?
And they're trained on their mob mentality of do it this way, gatekeep, But also, this is public money and they're doing public service and serving the public, and their applicants should be treated like customer service. So you have that like trade. So it is, I do think, and that is a criminal offence under MIPO, but that you can't challenge it in that way because people have no access to that legislation. So if people can't even challenge that homeless decision, how are they going to enforce accountability on that officer?
It's tricky though, isn't it? Because if you think of the ways of holding people to account for things, I mean, normally you would say you could make something a criminal offence to mistreat somebody in this context, or you could make it some sort of civil offence so that the council had to pay compensation, or the individual officer. But the danger is that the harsher you treat the people who do things wrong, the net result, I mean, it's not as if they're really well paid or something anyway. So it may just mean that people are saying, well, I don't think I'll take that job at the local council applying for as a housing officer because in return for this sort of fairly, it's not awful, but modest salary, I'm at risk of all this sort of unpleasantness, and so I won't bother. I think maybe management. I mean, what do you think? How do you actually who do you hold responsible? Is it if it is the housing officer getting told by their boss to not house someone, you can't really blame the frontline worker. It's the boss that you need to get to.
My position is that you can blame the frontline officer because they're an adult with capacity and they know what they're doing. But I appreciate it's hard. But I think probably the most pragmatic way of doing it is to basically multiply the amounts of compensation that are recommended by the LJ by like 10 or 20. Because at that point, that will really sting. So, rather than a £2,000 payment, you're making a £40,000 payment. You'd also potentially at that point, once that you get the ambulance chasing advocacy services that are taking a cut of it, but that's not necessarily a bad thing. And in my opinion, what has to happen is the housing sector needs, the staffing sector needs to basically reach that kind of crisis point where they either quit or they go on strike or they make a decision basically. And whilst we're kind of like ameliorating the whole kind of situation, kind of keeping it just good enough to kind of keep just enough staff there, just to kind of keep the wolf from the door, then you're going to perpetuate that kind of injustice. So I think, I say it's so corrupted by these different kind of processes of gatekeeping stuff that the only way you're going to do it is by putting a hefty penalty and putting staff to that point where they have to choose: are they going to keep breaking the law, or are they going to do something else? Are they going to raise a grievance? Are they going to use any one of the avenues available to them as a professional who is getting paid to do a job? Public officers are getting paid to do a public task or whatever. That's the only way you're going to fix this problem, because at that point you have a bit of a a watershed moment potentially where you might get some scandals out, but you might get essentially you get the public thinking about housing supply and that kind of stuff, and that's ultimately what has to happen for the kind of the problem to get fixed, in my opinion anyway. Appreciate it's very difficult to predict, but I think those if you look at something like the post office scandal, most of those people are absolutely culpable for what they did, and housing officers are doing very similar things. The kind of post office investigation team and an average housing officer, they seem to kind of be the same sorts of people often. And
of the
so I think
management.
that's kind of how it needs to happen.
Because the higher management are very similar,
And
claiming
I
not
think
to
they should
know
all be
things.
fined for when something's got, whoever was involved in the case should all be culpable for what's happened, not just a single
so.
officer.
I mean, if you compare it to solicitors, I mean, maybe a lot of people out there will probably say, well, solicitors are even worse. They mess people around terribly. But I mean, we are under a lot of pressure not to. And I mean, when we take on a case, we have to write a letter identifying who it is you can complain to if you're not happy with us, which I don't think local authorities do. And also, if we do anything dishonest, I mean, like anything, if I got drunk and did a runner from a restaurant, or I sort of dodged my fares on a train, I would get struck off as a solicitor. I wouldn't be allowed to practice ever again, because once I've shown I've crossed that line, I'm treated as being unfit to do the job. And so if you applied that to people in local government, they'd probably, I mean, it might put people off joining, but I mean, it doesn't put people off. I mean, you could pay them better, and then the penalty might seem harsher. But the other thing, what was I going to say? Yeah, like if you have higher penalties, like and higher compensation, like you said, Mike, then the first thing is, oh no, that'd be like America, where everybody's sort of suing everybody. But ultimately, the answer is that local authorities would then have to take out loads of insurance to cover themselves against claims, like solicitors do. We have to take out massive professional indemnity insurance, and then you've got insurers watching everything you do because they won't give you insurance cover, and that might be the way to do it. So that if people are getting complained about, then they have to report it to their insurers, and they would actually take a tougher line. But I think, as people are saying, and I'll get back to some of the comments. I mean, ultimately, if you're not, the problem is that there's a rights-based housing system, which means that people have a right to housing, whereas the actual allocation of the accommodation is resources-based, and so management are faced with a sort of dilemma of they can't say sorry, we can't do our job properly because we haven't got enough housing stock. They have to try and sort of massage it or come up with gatekeeping. But if they were under more pressure to actually say, what are we supposed to do? And it wasn't, the route to sort of getting promoted wasn't to keep your mouth shut and perpetuate the lie that it's all working and there's enough housing, then that might work as well. So I'm going to.
I think you need, but that's ultimately what needs to happen is the higher ups need to keep, rather than kind of just sort of burying the issue at management level or whatever, they need to be in a position where they need to then be vocal about it as well. Back in the day, like maybe 10 years ago now, the chief exec of like Surrey County Council or someone around there, they basically wrote a public letter to the government saying we don't have enough money to do our jobs lawfully, and they lost their job. But at least they did the right thing. They kind of, in one sense, that they kind of put it out there. And I think if a lot of people did that, if there was that kind of pushback from the sector as a whole, housing officers saying, I will not break the law anymore, I will not be in this situation where I have to break the law anymore, then again, it's not an act of God. The housing supply and kind of resources are not an act of God. They can be changed by political will. So, and I would say that, I think going back to, I think maybe you said it, Karis, but the housing officers would justify what they do by saying, we're saving the council money, but they're not saving the council money. They're saving, the council pays, it just doesn't pay from the housing kind of bit. We as a taxpayer, we pay the price of people being out of work and being unable to work because they're not housed. So it doesn't save money. It might save that particular little silo a bit of money, but it's not saving the public purse by leaving people homeless. It doesn't save money. We know this. As well as the kind of the impact on society it has by just fobbing people off all the time. So yeah.
The other question before we move on to comments, the question it comes up is whether they do know the law, but they're just pretending not to. Because if they knew the law, they'd do their job properly. But I think people are genuinely don't know the law, or they think. I mean, I spent about an hour just before I started this tonight. I was doing something I've been doing for years is looking at a priority need vulnerability section 184 notice, and it's so terrible. The decision is so bad, and the thinking and the way in which the law has been applied is so bad. I mean, all the classic examples, they didn't make any inquiries. They just left it to a person with mental health problems to present their own medical portfolio, as it were. We've considered the evidence you've provided. And then they've done the usual tests of saying, well, okay, so you've got personal independence payments because of your OCD and depression, but hey, you're not psychotic, and you're not you haven't been sectioned lately, so you haven't obviously got anything wrong. It just goes on and on like that, and you think, well, does this person really not? I mean, they must know what they're doing in order to mention the stuff, but they're mentioning it all wrong. It's like
it's a template. They'll be using a template,
yeah.
and I'd say, I think very few housing. I mean, I don't know. Maybe they should use like one or two people in the whole housing staff team that actually know what the law is, or something close to it. But the issue is that the housing officers aren't curious. So, like, if the housing officer says something stupid, you say, well, that's not right. Rather than saying, oh, where does it say that? How can I find out about that? How do we get to the truth of the matter? They just basically paint themselves into a corner and just argue harder. And it's like, I mean, again, it's a psychological phenomenon in bureaucracies. But again, they're adults with capacity. If someone is saying to them, you've got this wrong, here's a bit, I remember like taking the code of guidance to me several times and saying, you need to read this bit here, and they just wouldn't. They just would not have it. So that lack of professional curiosity, I think that's the bit they're culpable for. I don't think you can't blame them for not knowing the law fully, but they should be like open to learning and open to going on Google and opening the code of guidance to actually find out what the law actually says about something. But they shut down, and I think they, I don't know to what extent they I don't know if they know how much they're kind of just pawns in this game of gatekeeping. I'm not quite sure. I think some probably just genuinely don't know what the law is, and it doesn't occur to them to look into it.
But also they have a legal department probably down the corridor. They could go and ask.
Yes, but
Literally just knock on the door.
But the problem with them is, and I don't want to speak too unkindly of my legal departments, but having worked in one years ago, before I went to law school, I got a job as a locum solicitor, and I use the word solicitor with a small s, I guess, because I wasn't a solicitor, but a locum worker in a local government. And within a sort of day of getting there, I was doing stuff that I was way out of my depth. I had to look it up. I was taking children into care and stuff, and most of those people a lot of the people in the legal department know less than the housing officers, and they're people who, if you look at their job description, they're described as legal officer or something, which means it's shorthand for completely unqualified, so they don't really help. And again, the problem with the legal department is that there's two functions a lawyer can have. One is to advise their clients on how to behave in a lawful manner, and the other is how to defend them and get them off the hook when they don't. And unfortunately, the legal department is often just parachuted in at the last minute to try to sort of put some makeup on a pig and pretend it isn't one. Now, I'll just go to the comments if I may, because we've got Adam here saying, a friend of mine is having issues with the homeless prevention officer whereby they request documents for twice, then email 2 months later saying we require the documents or we will leave you. I mean, that unfortunately is quite a common experience. I mean, they there's two problems. One is that they request documents from people, and the danger is that gets done as a pre-requirement for processing the homelessness application. So here's a list of things we want. You've got to give them to us, and then we'll process your homeless application. That shouldn't happen. They should say, here's a list. Have you got them? If you haven't, we can write. I mean, the worst one is get a report from your doctor. I mean, people do get asked to do that. And they shouldn't do that. They should write to the doctor and also ask the doctor the correct questions. Because if you write to a doctor and say, tell us about Will, I mean, they might just print off their records. They won't actually. But if they say, what would the effect of homelessness be on Will, given that he suffers from this, this, and this, they might say, well, yeah, he would be likely to suffer more harm, than an ordinary person. So the Cheeseface has commented, oh, this is going back to what we were talking about before. Yeah, I mean, this is what I was saying, Cheeseface. If there isn't plentiful housing, then it won't really ever change, because you're just sort of playing a tortoiseshell game until then. But at least it won't be quite as sort of scamish as it is. So some councils seem to have subsidies carried out by law, but due to the shortage, encourage gatekeeping. Yeah, well, as I see it, that's the only way you can function. If the council aren't going to call out the problem and say it's a scandal, we're being asked to do this, we haven't got enough resources, then they will just engage in gatekeeping practices. And then I think we've had that one already. Yeah, sorry, Adam, you put that on twice, I think. I don't think. Oh, relieve them from the relief duty. I'm sorry, Adam, where it says we will relieve you from the relief duty, and the homeless person sent the email promptly with the document requested and hasn't heard back again and worried it may take another few months. What action can he take to speed up the process? Well, I think at the expense of sounding like a scratched record, I think it's just a question of complaining. Because if it's just a question of you haven't heard for 2 months, I mean, what I would do is, I think it's reasonable to expect to hear, not necessarily to have your whole application processed, but if you ask the council what's happening, you should expect to get a response to that within a week, even if it's just to say we need, because what they should say is, yeah, we're processing your application, we've got the stuff you sent, and we're making the following additional inquiries, and we've written to whoever, and we're waiting to hear back from them. Maybe you could, that's what I would do if my clients ask me what's happening, and I would say maybe you can chase up your GP, see what's happening. But if you go to council's websites, if you do a Google search for complaint, housing department, or housing, and then the name of the council, you'll usually get to some sort of online form or an email address. And if you send a message there, it may take 2 to 3 weeks, but you will get somebody usually getting back to you on that, even if it's just to say, sorry, we're very busy. But you will hear from them. It's not the most.
I think it's pretty useful to say as well, like at this stage, so whilst you're still in relief duty, then nothing's happening. You're not getting any closer to being housed, because the clock doesn't actually start ticking until the main duty is accepted. So although the relief duty is only supposed to last for 56 days, often, we hear questions on the channels and stuff about, people being left in relief duty for 8 months. Well, they're just literally in limbo. So if you want to take control of the housing situation, getting them to make the decision as soon as possible is one of the few things you can do to speed things up. Because once you accept the main duty, you could be many years, and at that point you've got very little control at all. But getting them to make the decision is going to be a good thing in most cases, assuming you're in priority need and stuff, or you're confident you are. I mean, if I've seen cases before where people just get forgotten about in the relief duty altogether, they're in TA and they get in another town or something, and they it turns up they're still there 12 months later, and actually they're not in priority need, so they're quite happy about that. But if you're in priority need, or you're confident you are, then it's in your interest to basically pursue them and make a decision, because as I say, until then you're not really any closer to getting housed.
That is one of the failings, I think, of the 2017 the Homeless Reduction Act, is that it sets up this relief duty and it lasts for 8 weeks, but it doesn't say what happens after the 8 weeks. I mean, in theory, they should then make a decision, but it doesn't say you have to make a decision within X amount of time. And so people are left wondering what's going on.
It gives guidance. So, I mean, that again, it's code of guidance rather than statutory limit, but then it was always, because before the HRA came in, councils had 33 days or 33 working days to make a decision. But with the HRA, they've now basically says they should make the decision on day 57 of the relief duty starting, and there's an additional 3 weeks if you need an extension. But so it should be no more than 11 weeks. And I think the LGO is probably has issued lots of complaint elements where you only get maybe £100 or £200 or £300 for the delay on the uncertainty, but it's still something where the council's not complied with that time scale. So I think I can't remember what else it says in that chapter, but it kind of says, council should have completed their inquiries by then. It shouldn't be still in the air, left hanging.
Yeah, I think so. Are you saying, sorry, the code, just to clarify that, the code of guidance, and I should look this up, does that set a specific time for how long you should go from the end of the relief duty to deciding on?
And that's what, well, yeah, as in like there's 1 day. So from the end of the
Oh,
relief
right.
duty, it's the day after.
Oh, right.
Because
So you should
I mean,
then make
again,
a
it's,
complaint.
yeah, if I'll just tell you what paragraph it is. If you search for the term day 57,
Can you?
it comes up.
Sorry, if I go, I'll go back to that page, and then if I
So
search
yes,
for
paragraph
code
14.17.
homeless code of guidance, paragraph
14.17.
14.17. Oh, 167. Whoops. There we go. Let's get that up there. See if I can get it from there. So 14.17, make that bigger for everyone. Where the housing authority is satisfied the applicant has a priority need and has become homeless unintentionally, the relief duty comes to an end after 56 days. Housing authorities should not delay completing their inquiries as to what further duties will be owed. Where the housing authority has the information it requires to make a decision as to whether the applicant is in priority need and becomes homeless unintentionally, it should be possible to notify the applicant on or around day 57. Yeah, so there we go. So presumably there's some get out stuff for the council to say, well, we haven't got all the information we need. But I think a complaint saying, well, we think you have, and anything else is just nonsense would be something people should make on day 58, I guess. So go to that website and say, but as you say, Mike, if for some reason they haven't given you temporary and they've used the relief duty as a sort of smokescreen to say, oh, well, everything's up in the air, we'll try and find somewhere for you, we'll get back to you, which they do. I mean, the people don't get offered temporary. Then the duty, if you're in priority need, then you shouldn't be messing around with it. Just say, give me temporary accommodation straight away. And the relief duty is a bit of, I think, for anyone who's in priority need, the relief duty is a bit of a waste of time, really. Well, it's precisely that. It's a waste of 56 days.
Yeah, and that waste, that's that council's resources that's getting clogged up.
Yeah.
The only benefit of that is if you're in priority need, but you're intentionally homeless, then rather than being housed for the reasonable period, which would typically be sort of 14 or 28 days, you'll get housed for 56 days plus that additional time frame. But other than that, I mean, I'm not sure if that was intended, but that's a good thing if you're intentionally homeless. But other than that, it's just makes it worse. And I think the other thing to say about relief duty is if you're not in priority needs and you're not housed on day 57, then they can just end the relief duty. Just ends. That'll be the natural kind of way. So although 14.18 says about not having a blanket policy, that's what councils do. If you're still homeless at the end of the relief period, so off you go. That's the end of our job. And we haven't achieved what we said we'd achieve, but there's no kind of there's nothing else for you.
But that's where hopefully, if I'm right, then the decisions the two cases I was talking about earlier, the Bexley case, was it? The one I said about where they hadn't considered helping him make a homeless a Part 6 application and they hadn't got to the nuts and bolts. If they haven't done those things, then you can say, well, the relief duty isn't really over because you haven't taken reasonable steps. You don't even know what reasonable steps are because you haven't done a proper assessment. And that is a challenge you can bring. So I'll just go back to Adam's mentioned about. Oh, sorry, I'll just go back to this screen. I'll bring the comment up there. We're getting quite close to the end now, but I'll try and get these last bits done. Unless anybody, so if anyone wants to ask any questions, get them in now. Okay, so here we go. A friend of mine asked about right to buy scheme, and it changed recently. If somebody was given a council home years ago, does the new policy change affect him from 2 weeks? Did I miss an earlier question? I may have done actually. Sorry, is it this one? Another friend of mine from Bristol is being assessed. No, that's a different question. Sorry, Adam, you got quite a lot of questions here, and I'm sorry if I've
googled the thing I think he's talking about, or he might be Shio, I guess. But so basically, the deadline you might have heard of on the November 21st was the fact that the discounts
That's
that
this
you
one.
get for right to buy returning to 2012 levels. So it then says, this is AI answer from Google, by the way, so I'm just reading from the screen. The maximum discount will range from 16k to 38k, depending on the area. For example, the maximum discount in London will be 16k, except in Barking and Dagenham and Havering, where it'll be 38k. So, yeah, I saw a little bit of buzz around it a month ago or so, but I didn't take any of it in because I've not really sort of seen any cases involving right to buy. But there was some kind of change. Now I don't know what it was before the change reverted or whatever, but I think that's what he's talking about.
Okay, and the other point here, which I think is a separate question altogether, is another friend of mine from Bristol is being assessed of being ADHD, and she wants to know how this will affect her case. Well, I think we get this question sort of in a number of ways quite a lot, and the question is, if you get diagnosed, forgive me if I'm missing the question, but missing the point, but if you get diagnosed with a condition, I mean, the simple answer to your question is it will affect your case, obviously, to some extent, but it isn't a sort of silver bullet that they'll say, oh, you got ADHD, sort of, come this way, we'll offer you something. It could be that they'll say, well, how severe is it, and what impact does it have? And it may make the difference between being in priority need. But if the person, I mean, also it'll affect the suitability of temporary accommodation. Although I'm not, do you guys have much knowledge of how ADHD specifically might affect temporary accommodation?
It would. So the answer is I don't understand it very well, obviously, because I talked about it maybe 4 or 6 weeks ago, and got some feedback afterwards that effectively it has a much broader kind of impact on people than I certainly realised. So I don't know the answer to your question, Will, but it does appear that it affects people in a number of different ways. Now, I can't immediately see how it would be, it would affect someone's suitability of TA, although it could well do, but I think it'd just be a case of making sure that someone with a diagnosis of ADHD is getting some kind of medical opinion about how it actually affects them. Because again, it's kind of some things, there's a range of things it can do to people. So I don't know off the top of my head, but I would say it's worth kind of looking into. Just a quick point there on that one, Will. So homelessness prevention officer keeps saying you have to wait 12 years in order to get one. Now, the average waiting time in Bristol is 898 days for a single person, which is 2.5 years roughly. So not quite as bad as the housing officer saying, but it's still a long time.
Yeah. One thing I would say, and talk about disorders that often people overlook, is that post-traumatic stress disorder, which is more common than people think, is actually pretty relevant to temporary accommodation, but particularly for single men who get put in hostel type accommodation, because that's exactly the sort of, post-traumatic stress makes people what's the word? Sorry, it's late in the day, not hypersensitive, but basically worried about noise and things like that. And you don't want to be bumping into strangers and things. And it's very commonly missed, that, and it was by me for years. But then I started getting psychiatrist reports on post-traumatic stress, and it is actually disorder, and it is actually not that ADHD isn't, but it is a very serious condition, and one which has specific implications for housing, and many people. I was talking to somebody about my father the other day, who was a veteran of the Second World War, and he couldn't hear loud bangs without jumping on, taking cover. So if I, as a kid, I went up behind him and fired a cap gun, he'd drop to the ground and get very angry with me afterwards. But somebody said, well, that's because he was suffering from post-traumatic stress disorder. And of course, we didn't think of it then. We just thought, oh, he doesn't like loud noises because he was in the war. But so many people, especially people who've come from, difficult countries in the Middle East, Somalia, and places like that, have really serious post-traumatic stress disorder, which hasn't probably been diagnosed. And so I'd recommend people, and maybe people don't talk to their doctors about it either. But if you do, then that would hopefully be recognised, and that's that. I went off on a bit of a tangent there. Sorry. Hypervigilant. Yes, thank you very much, Danielle. That's the word I was looking for. So I hope that is helpful. And it's now half past, so we've done an hour. And I think this is going to be the last session for this year, because next week is the 20. Is it, what's it today?
Be the 24th. Yeah.
Yeah, I mean, it'll be basically everyone will be.
23rd, sorry.
Yeah. I can't do next week.
No, I can't either. I'll be on my way to Poland next week. So I hope everybody has a really happy Christmas, and thank you for watching, and thank you, Karis and Mike, for your support with this. And are we still on for Thursday, are we, this week?
So I think yeah. I'm not going to. The one after is Boxing Day, so that's I can't do that. But yeah, this Thursday I'll be around.
Okay, so we'll be back for that then. So bye for now, and see you in the new year on this channel.
Cheers, guys.
Bye.